The next case to come before the court today is State of Ohio versus Scott Brundage. Each party will have 15 minutes to present its argument. Ms. Kelly, if you want to reserve time for rebuttal, just let me know when you take the podium, and I'll do my best to try to track that for you. The arguments are being visually and audibly recorded to be posted online, so please stay behind the podium, keep your voices up, and you both know, don't use the names of any victims or children. So we are ready when you are. We have read the briefs and are good to go.
Your Honors, opposing counsel, may it please the court, Attorney Angie Kelly on behalf of the appellant, Scott Brundage. The issue for the court's consideration today is whether the trial court abused his discretion in denying the appellant's motion to withdraw his plea of guilty. And we would urge the court to answer that in the affirmative. In this instance, Mr. Brundage was charged with a lot of felony charges and represented by two attorneys. He started trial. They had 1 day of voir dire, and then when they reconvened on April 2nd of 2019, appellant did enter a plea of guilty to 3 counts of gross sexual imposition to, well, totally 5, and 1 count of rape, in order for there to be a pre-sentence investigation and sentencing at a later date. That same evening, Mr. Brundage asserted that he wished to withdraw his plea, at least in conversation that he had with another individual. There's a recorded phone call from Mr. Brundage and the jail that was presented by the state in the hearing that the court allowed to come in that indicates that he immediately expressed that he wanted to vacate his plea. He filed a pro se motion. His basis for said motion is that he felt that he was pressured by his attorneys and given insufficient amount of time in order to be able to make a decision that basically affected the rest of his life.
Was this case pending 2 years?
It was.
I'm kind of struggling with the insufficient amount of time portion of his motion. Although I guess maybe there hadn't been any offers or anything up until that point.
I don't believe there were. Obviously, I don't have, I have a trial docket, but other than that, I don't have the evidence. But it's my understanding that although this case was pending forever, that there had been no real negotiations taken place until that day, and that it was Mr. Brundage's 2 trial attorneys who asked him if he would give them permission to talk to the prosecutor that night after trial started. So although there was some conversation, it was really a matter of you're going to find out while the jury's sitting there, or at least the prospective jurors are waiting to come in for day 2 of voir dire to make this decision.
Did he have the night to think about it?
I don't believe so. I know that the prosecutor argued that in there, but it was my reading of everything that there was a discussion of, we can ask about this, and that they talked to him at the jail that night, but then it was that morning of April 2nd that they presented him with the entire offer. I believe that it was finalized with the prosecutors in the evening when Mr. Brundage wasn't there.
Let me cut to the quick here.
Yes.
How is this not buyer's remorse?
It's our position that it is not buyer's remorse. It's based on the interpretation of the recording. And obviously that's what the trial court concluded, and I know that that's going to be a big issue for the court, and of course I know the court reviews all the evidence, and I as well listen to that. It's our position that Mr. Brundage, that recording is really, it's backing up his position that he didn't understand what was happening because it was instantaneous. Like, I think that if he had sat around and stewed about it and maybe came in like a couple days later, a week later, like, oh, I think I changed my mind about this. But it's all within this short span of time where he's just processing the entire thing. And we think, and what he said in that call, a lot of it was the exact same thing that he said in his motion to the court. So it's not that he changed his story or he waited or he delayed. I think that call indicates that he really didn't understand what was happening at the time. And I think failure to understand what's happening when you're walking into the courtroom is much different than just having regrets as to what you decided to do.
Well, I don't see an assignment alleging that there was any defect in the plea. So.
No, there was actually.
There's no dispute that the trial court at least explained everything.
Correct. The question question is really whether or not Mr. Brundage was confused as to what was taking place and whether or not he voluntarily entered that plea. And it's his assertions and what he verified during his hearing that his attorneys pressured him and that short amount of time was insufficient for him to make a decision that was this big of a deal for the rest of his life. And there is also, we are talking about a pre-sentence plea in which the law clearly states that prior to sentencing that the court should freely and liberally allow persons to vacate so that they can exercise their right to a trial in order to pull all the witnesses. And this was an immediate request. It's not after his pre-sentence investigation or after further discovery had taken place where he may have been intimidated to be looking back. This was, I didn't make this choice too hasty, I'm not comfortable with it, it was not voluntary. I can appreciate the fact that the court did assign him new counsel in order to handle the hearing, it did give him full hearing. However, we feel that in a case as serious as this, sentence is as serious, and the implications that are, because this is a pre-sentence plea, that the court did abuse his discretion because he should have had the opportunity to vacate.
By reading the briefs, I took that voir dire had been completed. Is that as far as the trial went?
Correct.
Was the jury sworn?
No. I don't believe that voir dire was 100% complete.
Okay.
If my recollection is right, they finished a full day of it and they were going to finish and impanel the jury the morning that he pled guilty. So,
Pausing you for a second. If you told me how much time you wanted to reserve, I didn't write it down.
I don't think I did,
Okay.
but let's go with 5 minutes if that's okay. I
You're good.
apologize, I just went into it.
I just caught it myself. You're good.
Okay.
Thank you.
So yeah, I don't think that, I know that they hadn't been sworn in. There's no issue of whether or not jeopardy had attached or anything along those lines. Like I said, he did file, there is a filed plea form, case law is pretty clear, that plea form is effective outside of verbal colloquy, but the colloquy did take place. So that is not an issue that needs to be addressed by the court. In regards to this issue, I'm just urging this court to focus on the fact that at pre-sentence, it should have been liberally applied, that he gave a basis that was legitimate to him, that we're talking about giving somebody an opportunity to preserve one of the most important constitutional rights, to have a trial and be able to present his case, and that he immediately requested the court to do so, and that he maintained the exact same position and basis for that throughout the entire process. And the court said that he had no evidence. I know that the state makes argument that his statement or affidavit is not evidence. But when we're talking about a conversation between two persons, I'm not sure what else there could possibly be. To support that, he presented the evidence that he had available to him. And that's that he felt undue pressure and was not understanding.
His prior attorneys were not witnesses at the hearing on the motion to withdraw.
No, one of them did take the stand, but it was incredibly limited because the court would only allow certain questioning due to the attorney-client privilege. So honestly, I don't know, I personally didn't see any value to the little bit of testimony that was presented in reading the transcripts, and the other one, no, he did not. The court took judicial notice of their competence. So there's not a question of their competence, but no, we don't know what conversation took place from the attorney's perspective because that testimony was not permitted. And it should not have been since there's privilege there, so.
So it comes down to this court's determination as to whether or not he presented a reasonable and legitimate basis to withdraw the plea.
Correct.
Because there's no issue as to the competency of counsel or the lack of a full hearing or any issues on the plea itself. That's basically the issue then.
Not in the record, no, there is none of that. I can certainly say that my client doesn't feel the same way about certain things, but I need a basis in the record, and that's how this court operates, and there is nothing in the record that indicates that his counsel was not competent or that it was not a proper plea. It is a question of whether or not the trial court should have allowed him to vacate due to it being such an early stage of the process. And we feel that by denying that, it was in fact an abuse of discretion. The court doesn't have any other questions, I'll rest on my brief for issue number 2. Thank you.
Good morning, Your Honors. I'm Jacqueline Corrigan on behalf of the state. May it please the court, the state is asking this court to affirm the trial court's judgment denying Mr. Brundage the opportunity to withdraw his guilty plea. A couple things I'd like to address right off the top is concerning what Mr. Brundage immediately did or did not do after he changed his plea to guilty. What he did not do was immediately write his letter. What he did do immediately was to have second thoughts about the plea that he had just entered. That's not the same as the kind of allegation that he made. And I would also like to remind the court that yes, this is an abuse of discretion standard, and I'd like to remind the court of what that means. An abuse of discretion is more than just mere error. It means that the trial court must have acted with passion, prejudice, partiality, the usual arbitrary, unconscionable, unreasonable kind of action that we associate with an abuse of discretion. And that also means that it has to be unjust or unfair. And, you know, this court really does not substitute its judgment for the judgment of a trial court unless it has abused its discretion. So even if this court were to say, you know, if we were on the bench and hearing the same evidence, we might have decided differently, that's not grounds for reversing this decision. Because if there was reliable probative evidence before the trial court that supports its judgment, then that judgment is not an abuse of discretion. And with this court, there was reliable probative evidence upon which the court based its decision that what Mr. Brundage actually had after returning to the jail after entering his plea was buyer's remorse and second thoughts. And that reliable probative evidence came in the form of the recorded call that Mr. Brundage made to whomever he was speaking to, in which he expressed that, you know, his attorneys had told him to sleep on the plea the night before. That's not coercion of the type that he tried to describe in his letter to the trial court. That he understood the sentence was going to be up to the trial court, and that he didn't want to do 25 years. He didn't want to do 10 or 15 years. And that if the trial court had offered him something, you know, in a lesser range that would have been certain, that he might have preferred that. And so if that had occurred, he wouldn't be asking the person he was calling to get in touch with his lawyers and tell him he had changed his mind. So that was the evidence that was before the court. And I would actually ask this court, to look over the full transcript of the hearing, the full hearing that the trial court conducted concerning Mr. Brundage's request to withdraw his plea. Everything in that transcript looks like the court was taking the language from State versus Key or Z, or I'm never sure how to pronounce that. XIE, thank you, I'll just spell it. Where the counsel's referring to that a pre-sentence motion to withdraw a plea ought to be freely and liberally allowed. That case doesn't stand for the proposition that every pre-sentence motion to withdraw a plea must be granted. That's not the case. But instead, when you look at the transcript of the actual withdrawal hearing, it almost looks as though that was where the trial court was going to go. That trial court was inclined to grant the motion until the court listened to Mr. Brundage's call from the jail. And then, when the trial court issued its ruling, the trial court refers very specifically to portions of that jail call, where Mr. Brundage says, and the court quotes, "Just tell his lawyers that I thought about it It would have been different if the judge would have gave somewhat of a different number today, but 3 to 29, that's a big stretch. And that's what the court quotes from his jail call. So that illustrates how the court had reliable probative evidence in front of it to essentially decide, no, all this really was a change of heart and second thoughts. And a change of heart and second thoughts are the essence of buyer's remorse. Instead, what Mr. Brundage bore the burden of doing, even in a pre-sentenced motion to withdraw his plea, was to present a reasonable and legitimate reason for withdrawing his plea. Not a reasonable or legitimate reason that's reasonable or legitimate to him, but a reason that's reasonable and legitimate to the court. It's not a subjective test based on what the defendant feels. It's what the court feels. And I would remind the court that legally we have a number of cases, many of which are cited in the brief, that a change of heart or buyer's remorse is not a reasonable or legitimate reason to withdraw a plea. Pressure or coercion by counsel has also been held not to be reasonable or legitimate reason to withdraw a plea, especially when the only evidence of coercion or pressure by counsel comes from a self-serving statement by the defendant, and especially when weighed against a proper, thorough Rule 11 colloquy like we do have here. In addition, this court has said, for instance, in cases like App.No, that it will affirm a court's decision to deny a motion, even pre-sentence, to withdraw a guilty plea, where the counsel had competent counsel at the plea hearing itself. There's no dispute that the two lawyers that Mr. Brundage had at his plea hearing were competent. Also, the second part of that is, did he have a full hearing at the plea? There's no dispute that he had a full colloquy pursuant to Criminal Rule 11, at which he was asked repeatedly, are you aware that you're waiving these rights, and was notified by the trial court of all the potential penalties he could face. And he said on the record that he understood those and was nevertheless entering guilty pleas to the reduced number of charges to which he was pleading. Finally, there was a full hearing concerning Mr. Brundage's motion to withdraw his guilty plea. And under Applewright, those three components urge this court to affirm the trial court's decision in this case. But in addition, I would also remind the court that there were two written guilty plea forms in this case, bless you. Mr. Brundage executed two of them. One detailed three of the charges to which he was going to plead guilty, detailed the potential maximum penalty, and he signed both of those. He claims he was pressured into signing them, but then again, I would also remind the court that we do have a transcript of the April 2nd hearing and pretrial well, not actually a pretrial, this was indeed the day after a full day of voir dire had been conducted, where the attorneys discussed with the court why they were going to be looking at a plea hearing rather than a continuation of the trial that had already begun, in which the defense attorneys, and this court has said in the past that the assertions by counsel to a trial court are presumed to be truthful, because attorneys are not supposed to lie to courts. So we can use their statements, bless you, as being truthful. They told the trial court that they had discussed the possibility of a plea with Mr. Brundage the previous evening, after talking with the state about whether the state would be inclined to offer him a plea where a life tail sentence would be taken off the table. They discussed that with Mr. Brundage after speaking to the state. The state indicated that the prosecution got a call from defense counsel around 8:30 to 9 o'clock the previous night. So that indicates that after the previous day's voir dire, defense counsel spoke with Mr. Brundage at length about this issue. Then they contacted the prosecution, and the trial court then gave Mr. Brundage's attorneys additional time after that and prior to the actual Rule 11 colloquy to meet with Mr. Brundage again, to make sure that that's what he wanted to do. So I remind the court that is part of the background of this. I would also like to very briefly inform the court about some of the other background of this case that the trial court makes note of in deciding not to allow the withdrawal of the plea. And that is that, yes, this case had been going on since 2017. There were 6 minor victims and 17 charges. Mr. Brundage fired his original lawyers on the day that the trial was first set to begin. New counsel was appointed for him. Those of the counsel were with him when he pleaded guilty. And so on the day, or the evening after the first day of voir dire, that's when they talk with Mr. Brundage and work out a plea with the state. And so that's the timing of this. And then the trial court receives Mr. Brundage's letter right before Mr. Brundage was to be sentenced. And so based upon that and other things in the record, the court agreed with the state that Mr. Brundage's request to withdraw his guilty plea was just another means of stretching out this proceeding to diminish the resolve of these minor victims, some of whom were under 10 years old when the acts that were charged occurred. So, again, we have legally, Mr. Brundage has not met his burden to show that he had a reasonable and legitimate basis for withdrawing the plea. Under Apple right, he had all 3 components of a proper plea: competent counsel, full hearing of the plea, and a full hearing of the withdrawal of the plea. And factually, the only thing that he presented was a letter that was self-serving. He was put on the stand and asked to confirm that, so it became the equivalent of an affidavit. But under the Supreme Court of Ohio's decision in Calhoun, that does not outweigh a self-serving letter or affidavit does not automatically outweigh a full Rule 11 colloquy. So there are no legal or factual grounds for the withdrawal of plea.
Am I correct that there was no cross-examination of him? And it was his testimony limited to verifying the affidavit?
That's correct, Your Honor.
And no cross-examination?
No cross-examination was permitted by the trial court. In addition, no cross-examination of his counsel, the one counsel who took the stand, was permitted, because the state wanted to get into, well, what did you tell him? Did you coerce him? Did you, stand too close to him? The state also tried to proffer that we would have had the testimony of a deputy who was in the room when that meeting occurred.
That was not allowed?
That was not permitted either. But the
Testimony wasn't permitted. Was the proffer permitted?
The state told the court what it expected the deputy would have testified to, and that
So it did make a proffer.
We did make a proffer, but the testimony itself was not permitted in the hearing. So unless the court has any questions, the state also would rely on its briefs for the rest of the argument, including assignment error 2, and we urge you to affirm.
Oh, I do have a quick question. As to the sentencing, excuse me, credit time served, I wasn't quite sure whether the state was saying, it sounded to me like you were saying at the trial level, the prosecutor agreed you should have gotten, oh no, that's the other case. This has not been a good day for me. I have no more questions.
We all need more coffee, Your Honor.
I needed to stay here on the other case. Coffee sounds great. All right, thank you.
Thank you.
Attorney Kelly, you have your full 5 minutes, or?
I have nothing further.
Nothing further? All right. All right, thank you both for very good arguments. We will take the matter under advisement, issue written opinion in due course.